Welcome back to the second hour of our program. Thom Hartmann here with you, and Judge Andrew P. Napolitano is with us. He is the senior legal analyst for Fox News, foxnews.com, the website. He's the author of 3 previous books, Constitutional Chaos, A Nation of Sheeps, and the New York Times bestseller, The Constitution in Exile. And he has a new book out titled Dred Scott's Revenge, A Legal History of Race and Freedom in America. Judge Napolitano, welcome to the program.
Thank you for having me, Tom. It's a pleasure, as it has always been.
Thank you. Would you recap for us, just very briefly, for those who may not be familiar with the Dred Scott decision that some would argue led us right straight into the Civil War, the essential argument that the court made in Dred Scott?
Dred Scott was a slave who was born into slavery in Kentucky and moved around with various masters to Missouri and eventually to Illinois, which is where he argued that he was free.
Illinois was a free state at the time.
Illinois was a free state at the time, and he filed a lawsuit in Illinois, and eventually the lawsuit moved with him back to Missouri. Though he argued that he was free, he was in fact still in bondage once he was back in Missouri. Now, the case goes up and down the court systems, up to the Supreme Court of Missouri and back to the trial court a couple of times. But when it gets to the Supreme Court of the United States, the issue is a fairly simple one. Is a human being who is black, once lawfully enslaved in a southern state that authorizes slavery, free because he has moved voluntarily, hasn't escaped, he has moved with his masters to a free state? Instead of saying, yes, he's free, or instead of saying, no, he's not, the Supreme Court came down with about the worst possible resolution of this. It said, because he's not a person, he doesn't have the right to file a lawsuit. Now, that argument that the government of the United States, the Congress, which had enacted the Fugitive Slave Law, which made it, which authorized any person, law enforcement or civilian, to grab a fugitive slave and return
any white person.
Correct.
Or
the states. Yeah. That means that the Congress or the states have the right to declare a class of human beings a non-person. Yeah. And that argument, though it sounds antiquated, finds its way into our law even today, when the Supreme Court in Roe versus Wade, 40 years ago, but still the law today, declared babies in the womb non-persons. There are other ways for courts to address things, but the idea that a living human being can be characterized as a non-person is a horrific notion that supports the idea that a popularly elected government can do whatever it wants.
Right. You know, I get it, and I get your railing against the Democratic majority here in the book. I'm curious.
Well, Democratic with a lowercase d. I mean,
yes.
I rail against all majorities that persecute minorities.
Majoritarianism, as you refer to it. Yeah. No, and I understand that, and we have had in the history of the United States majorities in favor of slavery, for example, in favor of women not having the right to vote, majorities that have been toxic, and I don't disagree with you on that. You know, with regard to Roe v. Wade, that's I think that we can put that into the category of another argument for another day. But certainly with Dred Scott, the thing that has always fascinated me, and I'm wondering if you will join me in this, about the Dred Scott decision, is that it was a personhood decision. It was not a slavery decision. And in 1886, in Santa Clara County versus Southern Pacific Railroad, the Supreme Court, although if you read the actual ruling, the Supreme Court did not rule that railroads have the rights of persons. But the argument was made before the court, particularly by Stephen, I'm forgetting his last name now, but one of the justices of the court, who was then the Ninth Circuit Court judge as well, because they rode the circuit. The argument was made by the railroads that the 14th Amendment, which said no person shall be denied equal protection under the law, because that 14th Amendment did not say no natural person. And as you know, at law, there are two kinds of persons: natural persons, which is humans, and artificial persons, which are corporations. They have to have some sort of personhood status in order to be able to pay taxes and things and engage in contracts. That the railroad said that because the 14th Amendment does not say no natural person, that they were a person. And John Chandler Bancroft Davis, the clerk of the court, after Judge Waite, Morrison Remick Waite, the Chief Justice, had died 2 years later, in the headnote to that decision, said that corporations are persons under the 14th Amendment. And although that wasn't legal precedent because it wasn't in the ruling, it was only in the headnote, there have been 34 cases that have quoted that headnote. And we now have, as established legal doctrine in the United States, the idea that a non-living, non-breathing entity, the corporation, has rights under the Bill of Rights. That Dow Chemical asserted their Fourth Amendment right to privacy when the EPA tried to fly over one of their factories to take photographs that a whistleblower had pointed out that they were illegally emitting benzene. That Nike has claimed First Amendment rights to lie to people in public relations and advertising. That Walmart has asserted 14th Amendment rights against discrimination when small communities try to keep them out. And in Pennsylvania, a number of large hog farming operations have done the same thing. Will you join with me in calling for a repeal of corporate personhood in the United States?
Oh, absolutely not. I mean, corporations have been persons for 100 years in the United States. If corporations were not persons, then the government would be free to do to them whatever it wants, and it could seize their property, stifle their speech, invade their privacy, and rifle their books whenever it wants.
But they're not human beings, sir. What's wrong with that?
I'm not in favor of relying on a headnote written by a clerk as a precedent in a Supreme Court case. Unfortunately, things like that happened in the old days when we didn't regard the Supreme Court language the same way we do today. It wasn't until the past century that there was just one Supreme Court opinion. For the first 175 years of the Supreme Court, all 9 justices gave their own opinion, and it was really up to the lawyers to interpret what the law was. They didn't actually start counting noses until around the 1890s and come down with one solid specific opinion.
But there still had to be a majority opinion. I mean, Madison versus Marbury was probably the most famous of the beginnings of that. It's
right, of course.
Back in 1803.
So that's how sometimes the summary of a clerk who is not on the court and frequently wasn't even a lawyer ended up being the type of statement that lawyers would rely on. Well, the clerk who was there, remember, this is before recording devices, the clerk who was there and heard this, or the clerk who was there when they argued it among themselves, the 9 justices, summarized it as follows. Now, that has happened in American history. No judge today would accept a summary by a clerk or a publisher of a headnote, which is basically just a summary of a portion of the opinion, as something having the value of precedent.
Except in Buckley versus Viejo.
Yeah, well,
you had Rehnquist saying in 1886 this court ruled. He quoted the headnote. He said this court ruled that corporations are persons, and that became the basis of the Viejo decision, the Buckley versus Viejo. It became the basis of First National Bank versus Bellotti, the 2 most recent cases that have given corporations the right to donate money to political campaigns. Again, if you're so in favor of human beings being persons, and you make a brilliant assertion of that in your book, and you're a valiant fighter for human rights, why do you think that a non-human, non-breathing entity that can live forever, that can own others of its own type, that can cross borders without a passport, that entity should have the rights that our forefathers fought and died to put into the Constitution?
Well, it doesn't matter. Most respectfully, I thought you brought me on to talk about my book and not an arcane principle of law. But I am a legal scholar, and I did teach constitutional law for 13 years, and I am familiar with this line of argument, and I'll go wherever you want because it is your show.
Well, we have about 30 seconds left. I mean, feel free to wrap it up if you'd like. I don't get how Dred Scott is any different than Santa Clara, frankly.
Well, Dred Scott was a human being
Right.
And you got me confused now, calling it the corporation. The court declared him a non-person.
Right.
If the court can do that to a human being based on an immutable attribute of birth, like the color of skin, then they can do it to any person, and that will
that's a terrible wrong.
Of natural right.
Yeah, well, we'll agree with that. We'll agree on that. That's
Thank you for
terrible
having
wrong.
me on your show.
Certainly. Judge Andrew Napolitano, the book is Dred Scott's Revenge, A Legal History of Race and Freedom in America. You can find more about Judge Andrew Napolitano over at foxnews.com. Thank you, sir.
You're welcome.
16 minutes past the hour.